And now your Idaho real estate news.
Are you guilty of making a call to a seller who currently has their property listed with another brokerage? This is Mike Johnston, contributing editor for Idaho Real Estate News. This week, we will discuss interfering with the brokerage agreement, specifically listed property. I have received countless phone calls from sellers, listing agents, as well as from other real estate agents and brokers about their sellers being contacted by another licensee. In these phone calls or other conversations, the sellers are being asked questions like, have they sold their home yet? How showings are going? If they are getting any offers? And how they feel about the services they are receiving from their current listing agent. This could even happen when an agent is showing the property, scheduling a showing, at the home inspection, or in any case where we are around the seller who happens to be there. We need to watch what we say and think about the questions we ask. As a real estate licensee, we should not be having certain conversations with buyers or sellers who currently are listed with another agent, whether that be a seller's representation or a buyer's representation agreement. We are interfering with a brokerage agreement. The Idaho Real Estate Commission, in its 2020 Idaho Real Estate License Law and Rules, states in 54-2054, paragraph 4, interference with real estate brokerage agreement prohibited. It shall be unlawful for any person, licensed or unlicensed, to interfere with the contractual relationship between a broker and a client. Communicating a company's relocation policy or benefits to a transferring employee or consumer shall not be considered a violation of this subsection, so long as the communication does not involve advice or encouragement on how to terminate or amend an existing contractual relationship between a broker and client, end quote. The Snake River Regional Multiple Listing Service also addresses this in its rules and regulations. Section 4.3, solicitation of listing filed with the service, quote, participants shall not solicit a listing on property filed with the service unless such solicitation is consistent with Article 16 of the Realtor's Code of Ethics, its standard of practice, and its case interpretations. Note, this section is to be construed in a manner consistent with Article 16 of the Code of Ethics, and particularly Standards of Practice 16-4, which states, this section is intended to encourage sellers to permit their properties to be filed with the service by protecting them from being solicited prior to expiration of the listing by brokers and salespersons seeking the listing upon its expiration. Without such protection, a seller could receive hundreds of calls, communications, and visits from brokers and salespersons who have been made aware through MLS filing of the date of the listing will expire and desire to substitute themselves for the present broker. The section is also intended to encourage brokers to participate in the service by assuring them that other participants will not attempt to persuade the seller to breach the listing agreement or to interfere with their attempts to market the property. Absent the protection afforded by this section, listing brokers would be most reluctant to generally disclose the identity of the seller or the availability of the property to other brokers. This does not preclude solicitation of listings under the circumstances otherwise recognized by the standards of practice related to Article 16 of the Code of Ethics, end quote. Many MLSs have these rules in place to not have situations like this happen. We, as members of an MLS, must abide by the rules, otherwise we may lose our membership in it. The above paragraphs in the Snake River Regional MLS, and similar languages found in most Realtor-owned MLSs, is there to protect the sellers from receiving these types of communications from other real estate agents. So why do agents still make these calls? I really don't know. Maybe a hope that the seller will consider them when and if the property doesn't sell. If I was a seller, I would be very angry with someone asking me those types of questions. I would call my agent and let them know what happened and express my dissatisfaction with that agent who called me, knowing that I already have an agent advocating on my behalf. What can you do when another agent is believed to have interfered with your buyer or seller representation agreement and has tried to get them to terminate your agreement and to work with them? First off, let me be very clear. I would first call the agent and have a conversation as to what happened. There are two sides to every story, and I would err on the side of caution by giving the other agent the benefit of the doubt. Most agents, after having a conversation with a colleague, will reevaluate what they have been doing, and most of the time they will modify what they are doing and will stop breaking the rules. With that being said, and after speaking with the agent who admitted to doing it and they refused to stop, then I would consider the following: filing a complaint with the Multiple Listings Service for a violation of the MLS rules, specifically solicitation of listing filed with the service. This would bring others aware of the violation and put the agent on notice that he or she is given a warning before any future actions may be taken by the MLS, which are notice of termination, attendance at an MLS orientation or other appropriate courses or seminars, a reasonable fine not to exceed $15,000, suspension of MLS rights, privileges, and services for not less than 30 days, nor more than 1 year, or even termination of MLS rights, privileges, and services with no right to reapply for a specific period not to exceed 3 years. I have found that this usually solves the situation. Most agents, when confronted with the MLS informing them that they are in fact breaking the rules, will change their behavior and stop breaking the rules. But what if they don't? What can you do then? It is a violation of license law, and you could file a complaint with the Idaho Real Estate Commission. I would, however, hold off and use that as a last resort if the agent doesn't change their behavior. We all need to be playing fair. We all need to keep our industry in a good light with the public. We all need to work together and help each other in the real estate industry. With this understanding, make sure you are not violating any of these rules. As licensees, we strive to give others a good impression, and it is harmful when sellers feel that we attack each other within our own industry. Remember, we should never speak bad about another licensee. This has been another segment of Idaho Real Estate News. If you found this article useful, please share it with others. Subscribe by adding us to your Alexa Flash briefing, or by sending an email to Johnston, Johnston, at mykro.com. We have a website with all of our past topics that have been discussed. Visit the website IREN.news for more information. There you can also submit topics you would like us to cover. You can also subscribe to our YouTube channel for more insights on forms and other real estate topics. For Idaho Real Estate News, I'm Mike Johnston.
Idaho Real Estate News is updated weekly.